Hello everyone, welcome back to the channel. I hope you all are doing great, and today we are back with yet another latest case of the Supreme Court of India. The case that we are going to discuss today was in fact suggested by Vivek in the comment section of another video. Thanks Vivek for the suggestion. I really liked reading all the 3 cases that you had suggested. And videos for the remaining 2 cases will also be uploaded soon. Well, if you are somebody who is watching this video and want to give any suggestions, you can leave that in the comment section below. So let's begin with today's case. This case is Geo Varghese versus State of Rajasthan, and it was decided on 5th of October 2021 by the Honorable Supreme Court of India. This case was decided by a division bench of the Supreme Court of India consisting of Honorable Justice S. Abdul Nazir and Honorable Justice Krishna Murari. This case was filed as a criminal appeal before the Supreme Court of India. So, Geo Varghese is the appellant of this present case. Geo Varghese, or the appellant of this present case, was working as the physical training teacher in St. Xavier School for students from 1st to 5th standard. Apart from being the physical training teacher, he was also a member of the disciplinary committee of the entire school. As in, he was a physical training teacher for students from class 1 to class 5. But for the entire school, for all the students, he was responsible to ensure discipline within the school because he was a member of the disciplinary committee of the school. A student from the same school, Nitant Raj Lata, a 14-year-old kid who was studying in class 9, unfortunately committed suicide at 4 p.m. on 26th of April 2018. Following that incident, on 2nd of May 2018, mother of Nitant Raj Lata filed an FIR. And this FIR was filed against the physical training teacher Geo Varghese, who is the appellant of this present case. And the charges were under section 306 of IPC, which is abetment to commit suicide. In the FIR, Nitant's mother had mentioned that on 19th of April 2018, when her son Nitant came from school, he had informed that his PTI teacher had harassed him in front of all the students. After that, on 25th of April 2018, Nitant's mother receives a phone call from the school authorities, and school authorities requested parents of Nitant to visit the school the next day. As in, on 26th of April 2018, they were called to visit the school or meet the teachers. And that same day, when Nitant returned from school, he again informed his mother that he was again harassed in front of everyone by the PTI teacher. And his mother said that they are anyways going to the school the next day, so they will discuss this issue as well. But hearing this from his mother that his parents are going to meet the school authorities, he came under some pressure and tension. The next morning, on 26th of April 2018, when his parents were about to go to school and meet the school authorities, he was unfortunately found hanging with the fan. There was also a 3-page suicide note that he had left. When the FIR was filed against the PTI teacher, he approached the Jaipur bench of Rajasthan High Court and he filed a criminal petition under section 482 of CrPC, seeking that the FIR which was filed against him should be quashed. However, Rajasthan High Court dismissed his petition. And that is the reason why Geo Varghese, the PTI teacher, approached the Supreme Court of India by way of this present case that we are discussing. The arguments from the side of appellant in front of the Supreme Court were that by reading the FIR, it cannot be concluded that Geo Varghese has as such done anything to compel the child end up committing suicide. Also, the 3-page suicide note that Nitant had left, that also do not prove anything against Geo Varghese as such. The first page of that suicide note mentioned, "All my thanks goes to my dear brother Kyron, even my love, bye buddy and sorry." On the second page of the note, he had written "needed justice." And in the third page, he had written Thanks GOPTI of my school. But in this 3 pages suicide note also, there was nothing written as such clearly which will prove guilt of Geo Varghese in any way. Further, if we consider motive as an important factor in criminal law, as such, the appellant was not having any personal reasons to harass the unfortunate child. In fact, the PTI teacher was a member of the disciplinary committee. Geo Varghese even pointed out that Nitant used to bunk classes sometimes, and for that he was warned by Geo Varghese plus some other faculties as well previously. And on 19th of April 2018, when Nitant for the first time went to his mother and told that he was harassed by the PTI teacher, that day also Geo Varghese caught him bunking classes, and so he was warned by the PTI teacher. Thereafter, on 25th of April 2018, when school authorities called parents of Nitant and asked them to visit the authorities, that day also Nitant was found bunking classes, so Geo Varghese again warned him. While deciding this case, the Honorable Supreme Court even referred to some of the previous decisions relating to abetment to commit suicide. Abetment involves the mental process of instigating a person or intentionally aiding a person in doing a certain thing. Without a positive act on the part of the accused to instigate or aid in committing suicide, conviction cannot be sustained. Honorable Supreme Court of India stated that being member of the disciplinary committees, Geo Varghese was anyways having a responsibility of ensuring that students are following the disciplinary rules and regulations. It was in fact duty of the teacher to scold students for rule breaking. And so the act of Geo Varghese in scolding Nitant because he was found bunking classes is not as such wrong. He was just performing his duties. The Supreme Court even said that as such there was no intention or reason for the appellant to force Nitant to commit suicide. And the step that unfortunately Nitant took represents a hyper step taken by the child which the teacher could not foresee. The Honorable Supreme Court of India even said that Rajasthan High Court was not right in blatantly dismissing the case without taking into consideration the facts of this present case. Supreme Court of India ended this case saying that it had condolence with mother of the deceased child, but the teacher's guilt is not proved in this case. So Supreme Court of India had set aside the order passed by Rajasthan High Court and under section 482 of CrPC quashed the FIR which was filed against the teacher. Well, section 482 in fact is very important, and many times cases are filed under it, wherein a person requests the court for quashing of FIR or quashing of some order or judgment of the court also. I hope you found some value out of this case. If you did, do make sure to like this video, leave a comment and share it with your friends. Until next time, bye-bye.